property. State versus Leslie Merritt, CR 2015-144211. Appearances, please.
Good afternoon, Your Honor. Leslie Merritt Jr. on behalf of the state.
Good morning. Good afternoon.
Good afternoon, Judge. Jason Lamb on behalf of Mr. Merritt, pursuant to Rule 9.1 with the court's permission. We'd like to waive his presence.
Okay. There were, the motion that was filed first was the motion to return property. So let's deal with that one first. Ms. Losico, I think it's your burden. I have read all of the pleadings. What purpose is served by keeping Mr. Merritt's car and Mr. Merritt's gun, which is, I grant you, is in pawn custody?
Your Honor, we are asking that the court deny the defendant's motion to release both of those items, beginning first with the gun. We do believe that the defendant does not have standing, and I'm going to refer to him as Mr. Merritt because he is no longer the defendant, Your Honor. Mr. Merritt does not have standing with respect to the gun being returned to him, as it was not in his custody or control at the time that the police seized it. Specifically, he had abandoned that property and relinquished it over to Mo Money Pawn.
In the defense pleadings, they talk about that it was a pawn situation, and so he has a right to retrieve it if he comes back in a timely manner.
And he did not. Instead, the police seized the weapon, so in theory, if the court is going to entertain that, technically the gun should be released to Mo Money Pawn, and then the defendant can retrieve it from there. However, outside of the standing issue, the state also would object to the court releasing the gun. Currently, it is our understanding that the Department of Public Safety is testing, doing additional testing. We have received, as early as this week, and I believe I'm supposed to be receiving sometime today, new DPS laboratory reports that we would like time to evaluate. Obviously, anything that's submitted to me today, prior to this, nothing has been submitted to me prior to this hearing, but I would like time to review and consider, and then make an appropriate decision from there. Similar with the car, it is my understanding, based upon discussions with the Department of Public Safety, that they are also going to be, or are in the process of conducting automobile shooting reconstruction, which is the state's reason for asking the court to not release the car back to Mr. Merritt.
You have a window of time that you're seeking permission to preserve this stuff.
I do not, Your Honor. At this point, I do not know what these reports will say, so I can't make that determination at this point.
You know if the car is being stored in an outdoor location or an indoor location?
When Mr. Lamb and I went to see it last, it was at an outdoor location. I don't know if it has since been moved.
Okay. You've answered all of my questions. Is there anything else on this issue, Ms. Losico?
No, Your Honor. Thank you.
Mr. Lamb, on the standing issue, I know that whatever property is, the police department is not going to take a liability concern releasing it to someone that they don't think it belongs to. So even if it was released, to whom would be the proper retriever?
Your Honor, as is evidenced by Exhibit 1 to our reply, the maturity date, if you would, of the loan transaction was November 28, 2015. In other words, Mr. Merritt had until that day to go back to Mo Money Pawn, pay the appropriate amount of money to get his property back, the gun in this case. The police seized it on the 17th of September. Therefore, if the gun were to be returned today to Mo Money, because arguably Mr. Merritt is indebted to the pawn shop for whatever amount plus interest they gave him, he would have approximately 2 months and 10 days. So I do believe it should go back to the pawn shop, with a caveat in the court's order that redemption period essentially was told by virtue of the police department's seizure of that gun pursuant to search warrant. I'd ask Mo Money to be endorsed on that so that Mr. Merritt's rights are not deprived.
What's my authority for that? And then I'm always reluctant to issue an order directing a party who's not here to do anything.
I think what the court could do is issue a provisional order, give Mo Money through its counsel 10 days to lodge any objections, and then it would become a final order of the court. So if they have an objection, they would have a due process right to be heard, and I'm certainly sensitive to Your Honor making any rulings that could affect someone who is not present here today. But Mr. Merritt will absolutely pay the required amount to redeem his gun. It is by no means abandoned by any stretch of the imagination.
So logistically, I release the gun. It's going to be to a person, because police department policy is going to want some person with an identification. Whose identity should I allow this gun to be released to?
An authorized representative of Mo Money Pawn or Mr. Merritt, in the event that satisfactory documentation can be presented, say on letterhead by Mo Money, that Mr. Merritt has fulfilled any financial obligations. In other words, if Your Honor makes a ruling that the gun be released, we will contact Mo Money directly. We will take appropriate steps, make appropriate arrangements, of course, furnish Ms. Lasico with a copy of the Department of Public Safety, sign any appropriate waivers for liability, so that then the gun could be released to Mr. Merritt directly.
And the car?
The car is an interesting issue, Your Honor, because if you read the state's response, they write, they may, and I stress the word may, need it for reconstruction. Well, there was a search warrant issued for the car back in September. The validity of that warrant to enter the car has long since expired. The state doesn't need the car, and I'll tell you why. Because in this case, there were a number of vehicles that were not seized, the victim's vehicles. What the defense did is a reconstruction by using clone cars. A 1998 Saturn is not a vehicle that is so impossible to acquire that the state could not do comparable testing on a clone or other suitable vehicle. That's what we did. We had no problem doing it. But to deprive an innocent individual of his property is essentially a de facto forfeiture. And no forfeiture notice has been given. The time has elapsed under 134308B for the state to, in fact, do so. There is no showing with specificity, as Kaczynski, a case stated by the state, requires, why this particular vehicle is necessary for the testing. It's a fairly common vehicle. They can get a clone car, just as we did for reconstruction, just as we did for the air pressure testing for the tire pressure expert that the court's familiar with. So the state, in essence, has made no showing whatsoever with specificity. I would tell the court generally they've had 9 months to do any testing. They've had 2 months since the dismissal. They've had 6 weeks since we filed our motion and put them on notice. Instead, they're asking for a further indeterminate period of time. What can they do with a car now that they haven't had the opportunity to do already? How many more experts need to look at it to say that there's no GSR, of course I'm getting the gun, that this wasn't the gun involved? So absent any specificity, none has been shown in the motions, none has been shown today, the vehicle needs to be returned. Mr. Merritt is a lawful owner of a car. He worked for it, he paid for it, he needs it to get to work, he needs it to transport his children. Most importantly, he's innocent. Hasn't he been through enough already at this point? The state hasn't met its burden.
Ms. Lasica, you have the last word.
Your Honor, the only thing I would like to add is that this is an ongoing investigation from the state's perspective, and so I'm not required to provide any specificity with respect to any of the testing or reconstruction that's being done. At this point, it is my understanding that we are awaiting results from the reconstruction and that the car is necessary for that.
Court has read the cases, find that the posture of this case is different in that this was a dismissed case, not to be flipped, but the state has had an opportunity to do in effect, two colonoscopies of the gun. I will allow that the state, one is in process, and to get the language and the people, because Mo Money is not present. I will order that the police department release the gun on June 30th, also to afford the state, if they seek to stay my order, you may, or to complete whatever examination is being done, you may. And for want of any other date, I'll make June 30th the release of the vehicle as well, so whatever tests you may do, have that window. With respect to the gun, Mr. Lamb, because I do think that the police will probably be very precise. If you give me who it is that would come pick it up, I will sign it.
Shall I lodge and circulate a proposed form of order that is satisfactory to both Your Honor and the state?
And yes, and I would check with whoever the custodian of the weapon is, so that we get whatever language makes them happy.
We'll contact them today, if not Monday morning.
Okay. Mr. Lamb, you had filed a discovery request for LH notes. I read all the pleadings. That one is your burden, so you go first.
Properly framed, Your Honor, does a defendant's right to obtain clearly exculpatory information, and conversely, the state's duty to disclose that same information, as is required by the U.S. and Arizona constitutions, as well as Brady versus Maryland and its progeny, survive a dismissal without prejudice when 1, the exculpatory information was in the possession of the state's agent prior to dismissal, 2, the state had a duty to disclose that information but failed to do so prior to the dismissal, notwithstanding a specific defense request in terms of a motion for discovery, which articulated a request that any notes or other memoranda associated with expert work be produced. And 3rd and finally, when the state has publicly threatened to refile charges. And the simple answer, Your Honor, is yes. The information possessed by the expert is imputable to the state through carpet. That information was imputable to the state as of the day they got the report, April 15th. Now, in the state's response, they indicate that they've made no request whatsoever for this information. That is akin to an ostrich burying its head in the sand. Clearly, the state had a duty at that point, whether it intended to dismiss the case or not, whether it had an inkling or not, to get that information and turn it over. This is not a post-conviction relief situation. This is not an appeal situation. Clearly, it's a little bit different. The state willfully did not turn over the information at a time at which they had the obligation to do so. I think that's fairly undisputed. The question then for this court is, does the state escape that responsibility simply by dismissing the case? And I think the answer is no, because it was a duty that existed during the pendency of the case, and because the state simply failed to abide by its obligations. And again, this is a dismissal without prejudice. If it was a dismissal with prejudice, I think I would be harpooning my own argument. However, in a situation where the case can come back and charges are being at least threatened to be refiled, the defendant is entitled to the clearly exculpatory information at issue.
You've all read your pleading. Anything to add?
I have nothing to add.
The court finds that this court has no jurisdiction to issue any order of disclosure. The court makes no findings of what the state had and what they disclosed or did not disclose. But there is no authority by this court to order a Rule 15-1 disclosure when there is no case pending. In the criminal arena, to the extent that Mr. Merritt has options to try to collect that in another arena, he may use that, but not 15.1. Anything else for today, Ms. Losico?
Not from the state, Your Honor.
Ms. Julian?
No, Your Honor, and I believe that concludes all proceedings under this cost number. So we thank you for months of attention and diligence.
You may be speaking prematurely. We'll see what the state
I
does.
hope.
Thank you. We are adjourned.
Thank you, Your Honor.